Welcome back to FDVN's channel. In today's video, we will introduce a new vocabulary lesson on the topic of drafting legal documents, language and structure. 1. Operative language. 1.1 Conditions. Conditions can take different forms. For example, when something must be done before something else may be done, condition precedent. For example, the consent of X bank must be obtained before the terms of this agreement may be implemented, when the performance of one obligation is linked to the performance of another. In this context, expressions such as provided that, on condition that, or subject to are frequently used. For example, this agreement may be renewed for a further period of 2 years subject to X having carried out the duties specified in Section 7 to the satisfaction of Y. Obligations, in the third person will refers to the future. He will go means he intends to go, whereas shall indicates an imperative. He shall go means that he is obliged to go. Therefore, in legal documents drafted in the third person, obligations are often expressed using shall. Shall is frequently overused to indicate the future. This should be avoided. Must is a good replacement for shall when expressing the imperative. If X becomes a party to this agreement, he must, immediately pay to Y. Must, or shall, indicates an obligation to do something. X must/shall pay the rent. Shall not indicates a duty not to do something. X shall not pay to Y. Must can also be used to indicate a condition precedent. In order to qualify for this position, X must is not required to indicates that there is not duty to do something. X is not required to pay Y to use the office premises.
Authorizations. Authorizations mean those situations in which a party is allowed to do something but is not obliged to do that thing. May is used in the following situations: to express a possibility that something may be done, for example, the company may purchase further products. To indicate that one has a discretion to do that thing, for example, the parties to this contract may assign the benefits under this contract. To indicate a wish, for example, the parties intend that the signature of this contract may signal the beginning of a mutually beneficial cooperation between them. The following words are generally used in the context suggested. Is entitled to indicates a party's right, for example, X is entitled to use the office premises. Is not entitled to indicates that a party does not have a right, for example, X is not entitled to use the office premises. May indicates a party's discretion to do something, for example, X may use the office premises. May not indicates that a party does not have discretion to do something, for example, X may not use the office premises. Limitations. Limitations mean words and phrases typically found in this context include, for example, no later than February 3, 2006. By February 3, 2006. Remains open until February 3, 2006. Limitations may of course take a number of forms: temporal, geographical, as to scope of activities, applications and responsibilities, though time limitations are perhaps the most frequently encountered of these. The word within is particularly useful in this context, as it can mean, inter alia, no later than, in a temporal context, within 14 days, or no further than in a geographical context, within a 12-kilometer radius. Here is some exercise. I need you to insert the correct word or phrase from the list and insert it into the sentences below. It may be necessary to use certain of the choices open to you more than once. 1. The consent of Remington Bank plc, A, be obtained before the share transfer, B, proceed. 2. The parties intend that this agreement, C, signal the beginning of a long and fruitful cooperation between them. 3. The seller, D, deliver the goods to the buyer no later than September 15, 2009. 4. It is contemplated that the parties, E, agree to further purchases of product A in the future. 5. this information constitutes a business secret. Therefore, the distributor, F, disclose it to third parties. 6. Since the firm does not have relevant expertise in that area of law, it, G, handle this case. 7. We, H, contact the vendors as soon as we have received the relevant information. 8. The question of the level of fees to be paid, be agreed between the parties, and it is possible that performance-related bonuses, J, also form part of the remuneration package. Here is the answer. 2. Structuring a clause. Each clause in a document should deal with a separate issue. The typical structure of a clause is as follows. Definitions of terms used only in the clause. The basic proposition. Exceptions to the basic proposition. Any restrictions on the scope of the exceptions. If the clause contains a number of sentences that deal with different areas of the main topic of the clause, these should be split into separate subclauses. Where the clause is long and complex, such subdivision is essential. When drafting a clause, the drafter should also consider whether that clause has any bearing on, or overlaps with, the terms of another clause in the document, and if necessary, eradicate any duplication or contradiction in the stipulation set out in different clauses. Ensure that each clause clearly deals with a separate issue. Where necessary, create explicit linkages between the clauses. For example, this clause takes effect subject to the provisions of Clause 7.